Caleb gave me one. Thanks, Caleb. Would you ask Jack to elaborate on the exemption and state statute requirement dealing with public law, so they don't think we are nuts. I think this is from Ellen, maybe? Okay. Let me see if I can't go into some of that stuff and things too. I've got a couple of stories to relate. Actually, if you're going to do the exemption stuff and things, you're going to find out most every court is not going to address that issue. The first kind of thing I'm going to talk about tonight, I was talking to Cindy Beers and some of the people out in Mesa, Arizona earlier today. Cindy said she's had an indication from several sources that there were a couple of guys that were being charged with something, most likely in federal court up in Minnesota. This just happened the last week or so. And these people went in there, whatever the charge was, I think she said it was probably on monetary units, like trying to pay things off with closed checks or something, drafts or something like that. And Cindy said these guys were charged with that, with, quote, passing bad paper, whatever it is, in the federal court. When they were pulled into the federal court to have their first hearing and arraignment on that, they immediately accepted the offer of the indictment for value, returned it for value. They asked for closure and settlement by the exchange of the exemption and requested that the order of the court be released. The judge and everybody, prosecutor, defense, whatever, they just looked at them like they're weird, strange, and nuts, pretended either that they didn't hear what they said or it didn't make any sense, and they kept going ahead. They tried to enter pleadings of not guilty. They had a second hearing, and the guys came back and did the same thing again. And then they postponed it to another hearing or whatever, and it eventually went into a trial. And whenever they'd ask these guys what they wanted, well, we've accepted it, we've returned it for value, we've offered the exchange of our exemption to discharge all public liabilities, we want settlement and closure and release of the order or the bond to us, and they were always ignored. So they went into a trial, and the public had their witnesses in this trial, and everybody got up as the witness and blah, 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 yeah, 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 they're all guilty and whatever. And so it got to the point where the public rested and the judge asked these guys whether they were going to put on a defense, and they basically stood up and said, well, we've accepted the charges for value, we've returned them for value, we've asked for settlement and closure, we've offered our exemption in exchange for the public charges and all of the fines and fees, and we're requesting closure and settlement, and they sat down. So the judge allowed the trial to go. I'm not sure if it was a jury or a court trial. Anyway, the defendants were found guilty. And then it went to a sentencing. And at the sentencing, the judge said, is there anything you'd like to say before I pass sentence? And they basically said, yes, we accepted the charges, we returned the charges, we asked for settlement and closure, we offered the exemption in exchange, and we request settlement and closure and release of the bond to us upon the closure of the case. So the judge says, fine, if there's nothing else to be said, then the first defendant got, I believe, something like 44 months of jail. And the second defendant, he got 20 months of jail according to the sentencing. And there were U.S. Marshals lining like the outside rows of the courtroom, and they had handcuffs in their hands, and they were ready to pounce on the victims, handcuff them, and lead them away. And the judge goes, no, 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 no. And so the marshals just stood there, and the judge looked at the two guys and said, that being said, we are discharging this case, and you two people are free to go. And they looked at each other in surprise, and they walked out of the court and went home. So Cindy says she's going to try to look into that a little bit more and confirm and give us any more information. She's going to try to see if she can get some transcripts of the proceedings. Yeah, like I think those are going to be probably readily available. Okay, and so I said to Cindy and the other people I was talking to, I said, makes perfect sense. I said, the issue was they were always defending themselves, the living offenders. They were never defending the defendant. They were never arguing his cause, never involved in any merits to the charges against them. Therefore, they could find the defendants guilty in the court because the defendants are the straw men that were created by the public. And since the public created them, the public can charge them, the public can crucify them, the public can do anything it wants to them. The issue is, though, that if the living soul starts in and defends the defendant, then he's joined into a commercial partnership with the defendant by defending the defendant's charges. So he becomes one with the defendant by way of a legal partnership. And we all know that if any partner to a partnership has a legal judgment against that partner, that the law can execute against any of the partners in that partnership to offset the value of the judgment. So if these living souls go in there and start arguing the case of the defendants who are charged to the merits of that case, then they become partners of the defendant. When the defendant's found guilty, they can incarcerate or they can fine and execute on the living soul who is basically arguing as a partner of the defendant. When these particular gentlemen did not argue the case against the defendant, they never joined into partnership with the defendant. Since they were being detained by the court in this activity, all they were doing is defending themselves, saying, I don't know what's going on, but I'm willing to accept it and offset any liabilities as a third party just to help everybody out in this matter. And so the judge ended up crucifying the defendant so the newspapers could write up their fancy article on how the defendants were found guilty and got 4 years or 2 years in prison. And then the judge says, and oh, by the way, you guys, I'm discharging this case, you guys can go home. Now, whether or not the reporters are ever going to follow up to see if these guys never went to jail or not is what the court's probably counting on, because there'll never be a backup story. So anyway, the concept was, and remember this, in this letter it says, can you elaborate upon the exemptions and why state statutes, regulations, etc., of public law, what can we rely on basically to help establish our position? Well, when it came to state statutes and stuff, remember that was in that civil case in which Sarah Fugate down in Florida was basically using state statutes to show what a legal tender was and what could be used, quote, as a money that the state would have to accept. And so she brought forth the state statutes not as an argument, but as a mandatory judicial notice to the court to take notice of the fact that money is more than Federal Reserve notes. So yes, there might be state statutes which would help you in your matter that you could bring to the mandatory attention of the court, but I thought what was extremely interesting in that particular case is that once again, the court seemed to totally ignore everything that these two offenders were doing. I have no information as to how long that period of time was from the time that they were first charged until they were discharged in that case. I have a hunch it probably wasn't 24 hours and probably was longer than 72 hours. But nevertheless, here's two guys that had been charged on some, quote, serious, unquote, charges dealing with commercial instruments, and the court saw fit to discharge the case against them, which meant they were entitled to the bonds, and to tell them, okay, go ahead and go home now. So we're seeing good activity come out of a lot of these situations. Now, in the last 2 weeks, because we didn't have a meeting last week, there's been a lot of things that have been going on. During that period of time, Nick Groshinen and several of his friends out in Idaho had their sentencing hearing. Remember, these are the guys that went in and pled guilty to the charges after they accepted and returned the charging instruments and agreed to plead guilty to the facts in the case in exchange for certain things. Well, it is extremely interesting what was going on here. Now, remember that they had pled guilty, and then the court held a hearing and found them guilty here about a month or so ago. And we had feedback from a couple of the people out in our tape land that were really upset because, quote, the court found Nick and his friends guilty. And if this stuff is working and if we're the creditors, why should they find Nick and his friends guilty? And we said, duh, because they pled guilty, number one, because that's part of the settlement, it's backwards. So they actually gave the court permission, first of all, to find them guilty. Okay? Well, Nick and one of the other guys went in for the sentencing hearing here last week. And, of course, Nick has been thinking about this for a long time and what he's going to do and say. Does everybody here know what an allocution statement is in a court? Uh-huh. I take that then as a no. Not everybody knows what an allocution statement is. Okay, if you don't know, then admit it, and we'll see what we can do to help educate you. Let's see what Black 7th. That is a problem. Okay, we'll spell it then, Caleb. Oh, for the virtual audience, there's raucous laughter coming from the back room right now. Caleb, maybe that's why they take your blanket off your table at your business. You're just no assistance. Allocution, A-L-L-O-C-U-T-I-O-N. In criminal procedure, first definition, a trial judge's formal address to a convicted defendant, asking him or her to speak in mitigation of the sentence to be imposed. This address is required under Federal Rule of Criminal Procedure 32C, 3C. Definition 2, an unsworn statement from a convicted defendant to the sentencing judge or jury in which the defendant can ask for mercy, explain his or her conduct, apologize for the crime, or say anything else in an effort to lessen the impending sentence. This statement is not subject to cross-examination. Yeah, the judge will say at the start of the sentencing hearing, is there anything you would like to say before I pass sentence? That is the draft to the convicted defendant to stand up and speak to the court to exactly what the definition said. To any acts or actions in mitigation of the sentence. What is mitigation? A lessening. To make it less severe than otherwise might occur. Now, after most allocution statements by some hard-nosed criminal, what comment does the judge generally make? The defendant has shown no remorse. So what is it that the court is really trying to hear out of the convicted defendant at the elocution statement? Apology, remorse, anything dealing with mitigation of that sentence. Why the judge should be lenient, extend grace, whatever's going on. Okay? Now, patriots have been classic in their approach to allocution statements over the last, 20, 30 years that I've been around the patriot movement. And when it comes to the allocution statement coming out of most patriots' mouth, what do you think they do during times of allocution? What kind of statements do they make? Yeah, pretty much so. Badmouth the system. You dirty, rotten sons of guns, you guys violated this right, this Constitution, these things. You people are in treason. Your laws are made by monkeys who've got special licenses. You name it, up and down. What is the patriot doing during allocution? Well, other than cutting his own throat, he's dishonoring the whole proceeding, placing the blame for his predicament back on the system instead of taking responsibility himself. Which is usually like a beep, hello, wrong move, dude. Okay? Now, with this commercial procedure, what's very interesting in the commercial procedure is a lot of people now are beginning to perceive that most of the things going on in the courtrooms are commercial. But they also like to tend to think of most things going on in this commercial activity as like contract nature. And we've talked about that here in the last couple of months, that there can't be any contracts when there is no money because there's no ability to execute the contract and to close it and settle it. So we really haven't got contracts. All we have is constructive or implied trusts, because a trust can go on forever until money occurs so that you can close the transaction. In any event, most patriots involved, or a lot of patriots involved in the allocution right now, have heard some stories where patriots have got into the court, and I know I've heard some of these stories, and the judge asks during allocution, is there any reason why I should not pass sentence? And the patriots, now thinking that this is totally commercial, are standing up there stating such things like, I don't accept the charges, I don't accept the judgment of the court, I don't accept the finding of guilty by the jury, and I don't accept your ability to sentence me to any time, and I'm leaving. Under the theory that they've heard that, why are people in jail? They volunteered. So obviously, if people are going to jail because they're volunteering, the best allocution statement is to just walk in there and tell them, I don't volunteer and I'm out of here. And then, since the only way you go to jail is by volunteering, and they don't have my agreement, they got to let me go home. Now, those stories are floating around, and if in fact one or two times that may have worked, I would suggest strongly that if it worked, either A, the court didn't want to put the guy in jail that bad, or B, they didn't know what to do, or C, they just let a ringer go by in hopes it would trap some more people down the road. In any event, my friend Nick was going into sentencing And he was concerned for more than a month or two what was going to be his statement of allocution when the judge basically asked him, "What would you like to tell me before I pass sentence?" Now remember, Nick had already pled guilty to the facts of the case after having accepted the offer, returned the offer, and offered to exchange his exemption to discharge any public liability. Now, he had been negotiating with the prosecutor, and actually he'd met with the judge and the prosecutor several times, and they were actually very pleasant, nice people, and they had some very good conversations. But the public prosecutor and the judge had their job to do, and Nick had his job to do along with his friends. And there were times when Nick had, in fact, explained to the prosecutor basically exactly what was going on, but off the record. And the prosecutor was very inquisitive and interested in a lot of these concepts, but again, he had a job to do. And Nick wasn't trying to justify or explain things, he was just chatting with the prosecutor because they were both interested, and they both, to a certain extent, became friends. After all, shouldn't you love your enemy? Aren't you going to get your remedy through your enemy? So Nick was thinking what it was he was going to say. And he went to a couple of different patriots and he asked them to supply him with some thoughts and concepts on an allocution statement. And Nick was going through some for himself, and his one buddy that was going in same day, basically same time, was also going to be going through his, and they were chatting amongst themselves. What were they going to do? And what's interesting is that before you go in for sentencing, usually there's at least about 30 days between judgment and sentencing, because during that period of time, if the defendant is found guilty, probation departments, either state or federal, generally are given a job of investigating the record of the straw man defendant in the public system, and they come up with recommendations to the court on terms of sentencing and sentencing guidelines based upon numerous factors: seriousness of the crime, past and present facts related to the defendant's record, whether or not there is restitution, whether or not there's remorse, whether or not the defendant may be of harm to the public, whether or not he may do the same act again, and numerous other things. And so the probation department prints up or does this report that the court is going to use basically as a guideline in the sentencing. And usually, be it federal or state, the report is to be made available to the defendant prior to the sentencing hearing. And it depends on the rules and regs whether or not the defendant can get a copy of the report or whether he can only come in and see a copy of the report or whatever's going on. In any event, there is a report. Now, the obvious offender today, understanding commercial models of things, is going to look at this report that is going to be tendered by probation to be another commercial offering to the offender in this case. And so naturally, your first reaction is that whatever's in that report, A, you can argue about it, or B, you can accept it and return it and request that you have the order released to you, and you'll underwrite whatever it recommends in terms of any kind of satisfaction with regard to the sentencing. And so there were some written reports for Nick and for his friend. Now, Nick had been offered to go down and look at the report, but they couldn't make a copy of the report and they couldn't remove it. And Nick never got in there to see it. His buddy had gone down. He'd looked at his. and he was ready for what was in his report, etc. So they showed up the day of sentencing. And both Nick and his friend were sitting in the court, and the judge called Nick's case first. And Nick goes, okay, I'm going to be the guinea pig, I guess. And the judge said, have you seen your pre-sentence report? And Nick goes, well, no, Your Honor, I haven't had a chance to see it. And the judge says to the prosecutor, you got a copy, give it to Nick. He's got to have to read that before we're going to move forward in sentencing. So he looked at the other guy and said, you read your report? And he said, yes. So the judge said, okay, you get up here. So they took him first while Nick was reading his report in the background. Now the judge looked at this guy and he said, do you have anything to say before I pass sentence? And the guy looked at the judge and said, yes, Your Honor. I want the court to know that I have accepted the pre-sentence report for value. I'm returning it for value. I'm requesting the order of the court be released to me. And then he shut up. And the judge looked at him and he said, do you have anything else to say to me? And the guy looks back at the judge and he's like, well, where's the judge going on this? And it's like, hello, I shouldn't be really talking about the case. I'm going to be the debtor. I'm supposed to be the creditor. So he looks at the judge and he said, well, Your Honor, I've accepted it for value, returned it for value, and request the court release the order. The judge said, do you have anything else to say to me? The guy said, yeah. He says, I want that acceptance and return on top of the pile. And the judge goes, okay, we'll put it on the left side of the case, on top of the pile. What's that just tell you? No, left side is the public side of the folder. So the judge is saying, you want it there? I'll put it there. It's right on top. It's the last entry so far on the public side of the folder. Is there anything else you would like to tell me? And he thinks about it and he goes, boy, he says, I must be screwing up here. This judge keeps asking me and asking me. Man, I must be screwing up. So he basically says to the judge something about the fact that, well, Your Honor, going into this hearing, I accepted the case, I returned the case, and I offered to exchange the exemption. And he said, I don't want any jail time in this matter. And he says, I don't want any fine in this matter either. And he said, I'm asking for settlement and closure. And the judge says to him, is there anything else you would like to tell me? And he's going, where is this judge going on here? And he finally looks at the judge and he says, no, Your Honor, I have nothing else to tell you. And the judge says, okay. And he says the following then to the judge, or the judge says the following to him. He says, if it's okay with you, would you mind if we postpone the sentencing hearing for you for 30 days? And so the guy looks at him and he turns around and he looks at the audience, and my friend Nick's back there and some other people, and they keep going,